In the course of your estate planning, we may provide you a will, and if you have a trust, a revocable living trust, you're going to have a special version of a will that is called a pour over will, which ties directly to your trust. If you are a client that is not using a revocable living trust as part of your estate planning, please note there is a separate video for wills that we use for that particular purpose, because those wills are a fair amount longer and a fair amount more complicated than the pour over will that we're going to have here. However, if you do have a trust, then this is the will that you're going to have. Now, as a reminder, the purpose of estate planning is that we're going to prevent probate from happening. We're going to properly retitle our assets, directing them to the trust so that those assets don't get stuck in our name to have to go through probate. So when we achieve that, we don't end up having to use our wills, because our wills only have to be activated if probate is required. However, for the sake of having backup plans, we will always want to have a will that ensures if probate happens, here are the processes, here are the people, etc. So there's no question and there's no opportunities for conflict. Now, in having a pour over will, the document is going to be much shorter than a standard will, because we don't really need to itemize much of the details of where everything is going and how it will be managed, etc. That is the purpose of the trust. Your will is called a pour over because, in effect, we're going to take anything that's left over that's in your name and we're just going to pour it into the trust, and the trust will take it forward. So at the start of each will is going to be, who am I and where do I live? If you have been married before, had a maiden name before, etc., we're going to always want to itemize those other names that you've used, because should something come up ever in one of those prior names, we just want to make sure that we catch it here in the will. Article 2, if you happen to have any family, spouse, and children, then we're going to itemize here, who are those people? Who is my spouse? When were we married? Children's names, birth dates, etc. When we have stepchildren or like a blended family, as an example, you may see language in your will identifying that this children is part of our family, but they're my spouse's child, as an example. We're not saying that you adopted that child or that you're extending any additional legal responsibilities to them, but we are identifying them here because they're part of the planning, they're part of the inheritance. In Article 2, 201 is going to reference something that we're going to go through in a little bit more detail with the trust itself, but the basic idea being, if I am gone and I have left behind any guidelines, any instructions about what to do with all of my stuff, my personal property, then this is something that's going to be carried out. So in this case, it's simply referencing, if I ever wrote this up, my trust is then going to be responsible for carrying out those wishes. 202, this is that pour over provision. If there is anything that's left over in my name after I'm gone and it didn't end up in my trust, put it in my trust after. And then alternate disposition, you're going to see 203. I have never once in my entire career seen this happen, but my job is to do backup planning on top of backup planning. So in alternate disposition, we're providing, if for some reason this trust can't be located. Let's say, for example, mom and dad wrote the trust in 1975 on a typewriter, and there's only one copy and we can't find it anymore. Well, that's okay. If the trust can't be found, then we're going to again, I've never actually seen this happen, but it's there. There is a further provision at the end there that just says, if for some reason the trust just completely fails, then here's where everything's going to go as a backup plan, typically to spouse, then to children, or any other people that you may have designated. Sometimes we'll just delete this section altogether when we're not leaving things to family. Article 3 is going to contain any people that are listed. So number 1, if there is ever a need for an executor, a personal representative, we're going to identify those people in 301. This is typically going to be the same line of people that we put into the financial role, the financial power of attorney. because they're doing the same thing for us, just kind of at different times. And then two, if you have children under the age of 18, then if I'm gone, who would step in to be guardian of those children? So in any instance where you have people listed, make sure they're still the best people. If not, tell us. And then, of course, if we need to correct a name like a spelling, just notify us and we'll make those updates. That is honestly it in terms of your individual planning for purposes of the pour over will, and we're only on page 2. The remainder of this document is boilerplate language in order to just solve any issues that come up later. So as an example, section 303, it says the person who becomes guardian of my child also becomes their money manager. We call that the conservator. Article 4, if I need an executor to step into my shoes, here's all the powers that they have. And we're basically just saying all of the powers that Colorado state laws provide, that's the powers that they have to take care of my affairs. Article 5 is all basically about how probate works if probate has to happen. So 501, for example, it's basically just saying you need to administer this as timely and efficiently as you can. And the trust specifically that I have established doesn't need to go through probate. It's only the assets that are going to go through to get to the trust. 502, for a very long time, all states have had a law that basically allows judges to require an executor, a personal representative, to post a bond in order to be able to serve. It's incredibly rarely used, but it still exists. And so we want to make sure under no circumstances would my personal representative have to post a bond in order to be able to wrap up my affairs. 503, there are different types of probate that exist. So we're just saying here, use the simplest form of probate that is available to administer my estate. And in Colorado, we call that informal probate. And then finally, 504, the person who serves as your executor, your personal representative, as well as your trustee, as you're going to see in your trust, they are entitled to ask for reasonable compensation for the time and effort spent. Now, this is really just opening the door for that as an option. So number one, it is optional. The person who's doing this for you does not have to be compensated. And I find a lot of times with family, with close friends, people don't ask for it, but they can, especially if they're spending a lot of time and effort. Compensation, the process is pretty heavily regulated by law. So if somebody did ask to be compensated, they're usually then going to follow up with somebody like me, an attorney, or maybe an accountant to be able to understand what that is and how they go about doing it. Article 6 is just going to address final finances. So 601, payment of taxes and claims and expenses. This is honestly just referencing over to your trust, and it's saying any final finances that need to be resolved. My executor, my personal representative, you're just going to do that in conjunction with the trust, who's going to end up paying for those things. Tax and administrative elections, 602. It's just important that the executor, in order to minimize any taxes that you may owe after you pass away, that they have the ability to make any elections available under law to minimize your tax debt. And this is just saying that they can. General provisions, just miscellaneous provisions. So 701 is an example. It's important to identify that if somebody is adopted into a family, or if somebody is born after I die, they're still a member of that family. So they're going to be considered a descendant, an heir, in the same way that all of the other descendants are considered. 702, as an example, you're creating the will under the laws of Colorado. Even if you move to another state, that's fine. This is just saying it was validly done here. 703, there will be a more detailed provision in your trust, but very importantly, nobody is allowed to fight. Fighting in this context is very expensive and frustrating and time consuming. So this is preventing that. We'll talk about that in more detail for the trust section. And these remaining sections are basically contract terms for how we're going to interpret the will, interpret the contract. At the end here, there's just signatures. So the will is a very simple and quick read, and you're likely just to read the first 2 pages. But if questions or anything come up, obviously, please feel free to ask them. Just keeping in mind, our goal is that we never end up using this will. For much more detail about the trust that you're establishing, go ahead and view any of those videos about trust.